computer in your office for 2 hours.
I agree. We probably need to explore that. My opinion would be, based on where we are right now, that it would be something we would need to approve. But I
And
think
we did the online, or the webcast
Yes.
in the fall. You know, my question is, are we continuing to go and pursue that now? I mean, we did the one.
We did two.
We did two.
We did two.
Okay.
And yes, we're going to be offering those again, probably starting in October, maybe September.
Okay. I mean, I just want to ensure that we have a limited number of people that we can trust to deliver the right material. Because a company in California delivering a Tennessee-specific ethics course,
Makes you wonder.
yeah,
Um,
it's not me
Totally
wanting to
agree.
keep people from out of Tennessee from providing services. It's just a matter of
But we don't
caution.
want, yeah, we don't want them taking advantage of,
Our rules.
exactly.
Yeah.
Can we just recommend that we discuss it on the full board?
I think that's something we do need to discuss, but, so you want to hold?
I don't know if that prevents you from approving I mean, I guess it's got the content. I assume y'all have read the content, but I just think it's a bigger topic than just approving one course.
I do too. So that's why I
Yeah.
would recommend that we push it up to the full board.
Okay, that's fine with me. The next item is a review of the Life Office Management Association exams for approval as CPE. The LOMA exams are necessary in earning the Associate Life Management Institute, ALMI, and Fellow Life Management Institute, FLMI designations. We've had several requests for CPE credits for these exams, which are geared towards the financial services industry. In the past, we've granted pre-approval for CPE credit for the LOMA exams. So I guess they're wanting a blanket just to be approved without having to get individually approved for these exams. Is that?
Yes, we'd like to put it on the list of the approved exams so that they don't have to get the individual approvals.
Does this work like the CMA exam where there would give some 30 hours or something? How are we looking at granting a number to it?
Okay. The current rule, I believe, Dr. Spiceland, is 5 times the number of hours that it takes to take the exam. And then you can also earn credit for any prep courses that you take. I don't think there are prep courses for this. So you're looking at giving them simply time for the exam.
Roughly 4 hours for an exam.
4 hours for this exam? It's one exam that's 4 hours to get,
I believe there are several parts, several different levels of it.
What type of CPE do y'all grant for this? Is it other?
As their pre-approval requests, we've just been doing it as non-technical.
I guess the question I had when I was reviewing this, I didn't know how this was relevant to the accounting industry. Can you kind of give me a brief synopsis? I assume it's more insurance related.
Aaron, that's your bailiwick.
Well, this is something, most of the requests we get from this come from Unum. Their finance department encourages their CPA employees to get these certifications, and you have to take the LOMA exams to do it. I think there's a lot of emphasis on financial reporting, investing, risk management, business law for financial services.
so when we've granted it though, it only counted as non-technical. So they still had to. You know, Karen, how is each part a 4-hour test, like the certificate level 4 hours, the next level 4 hours?
I believe so, yes.
I'm not sure that it closely relates to accounting, but I'm also not sure it's going to apply to that many people. How many people are going to take these exams?
We've granted this in the past, right? Just on an individual basis. Is that,
Yes.
Part of the information that I got from Unum, from Linda Emery there, she was the one who I was talking to about requiring or requesting that their CPA employees get this. She says that the courses, the exams are helpful in providing a top-level view of the industry and how the different pieces work together and tie into the financial statements. So I think they find it helpful in combining the insurance and the accounting aspects of what the CPAs do there.
I mean, when I'm looking at, for example, the certificate level doesn't seem to have any real connection. When you get up to the FLMI level, I can see that it definitely does. The ALMI is a little shaky. So I guess that's my only question.
I was just reading from their summary about level 1 certificate talks, it says foundational insurance concepts. The ALMI is the core insurance functions and financial literacy. And then, yeah, advanced insurance and financial concepts. I mean, that was the issue I had, was this primarily just an insurance course that had some sprinklings of, accounting related topics, as opposed to, was it real intensive accounting?
I would be okay with approving the FLMI level, maybe even the ALMI level, but I don't think the certificate level exam doesn't look like it brings in enough accounting to count as CPE. But
Even under the ALMI level, the 301 course is just insurance administration.
right.
And then insurance marketing and marketing and financial services, the 320 course, reviews the various elements involved in selling insurance products and the functions of marketing as an integral aspect of the life insurance industry. And that just seems like more like a marketing course.
But we're looking to approve this as non-technical, right?
We're limited on the pre-approval requests to 16 hours of non-technical credit.
What I'm trying to get to is, if it's non-technical, the fact that it doesn't encompass accounting.
Well, if we approve it as a CPE, I don't think we can we limit that? Or, do we just have to say it's approved for CPE?
You can limit it to being other CPE, I believe, Dr. Spiceland. It looks to me that the FLMI level is probably accounting, and therefore would qualify for technical credit. If you wanted to simply approve the FLMI level as one of the pre-approved exams, then you can do that, and we'll count it as technical.
I would move that we approve the FLMI level.
Second.
The last one we have is a request, consideration of business valuation courses as technical CPE. Request from regarding an employee of a firm that had 78 hours of business valuation classes, and which we grant now is what, other CPE?
It doesn't count toward
Non-technical.
accounting and auditing.
Doesn't count toward accounting and auditing.
I believe that's what the real
Yep.
issue is.
Yeah.
I mean, my,
Ask a question before we get too far into this, if you don't mind. Chris, I do a fair amount of valuation work, so I obviously
I think it's reasonable if you wanted to offer any insight you have based on your experience in the field, but if it's, I would say, if it's a close call as to whether a Monday morning quarterback could say you're voting in your own self-interest, I'd go ahead and recuse myself at the voting stage. So if your fellow committee members or anyone on staff here has questions from somebody who actually does this day in, day out, I think it's probably fine for them to ask. But come voting in motion time, I'd probably recuse myself.
hard to interrupt. Just
my opinion is, and I don't do business valuations, but I mean, I think it's very technical and reading, the courses that they do and the requirements they do. I think it's very well along the lines of accounting, and should qualify, in my opinion, as A&A.
I've taught a course. It is very, I agree. So I'd make a motion, but I don't know. Can the two of us do that?
Yeah, we've got to.
We have to have a
Quorum
third. Do
with
we have
Trey.
to bring it up to the
If I'm
board?
able to vote in this-
Your next officio member, yes.
But I
You may-
can't vote.
Yes,
Yeah.
yes.
I'll make the motion.
Okay. I second.
Accept it as technical.
Yeah, I agree.
I second.
Okay, that's all the items we have. Any other things we need to discuss? Ask for a motion to adjourn.
I have one quick
Okay.
item, and I'm not even sure if this committee is really where we need to take it up, but we had a situation happen in our firm recently that I thought was a little unusual. We were engaged to do a pension plan audit by a company in Kentucky. Went up to do the audit and received a letter from the Texas State Board of Accountancy saying that we needed to register in Texas because the parent company was located in Texas, and that they have some rule about that. And I just thought it was unusual. I mean, how would anyone know that the parent company is in Texas? And
Good question, Vic. That's one of those things that the states keep up with. Here in Tennessee, we have firm mobility, so we don't keep up with that. But in Texas, they're very particular about who does what in their state. And
but I mean, we didn't go to Texas. That's the point.
but the parent company was in Texas.
Well, I understand, but we didn't know the parent company was in
Do you
Texas.
think the
Fine.
company ran a check before they
No,
approved it?
Texas, they told us how it came up. They get a list from the DOL of audits regarding companies that are in their state, and they compare that list to people who are registered, or firms that are registered in their state, and then that's how you get the little letter.
Huh.
What kind of work were you doing?
A pension audit, pension plan audit,
Okay.
for one of their subsidiary companies.
Yes, that's a new thing that you just got the letter in the last month or so.
Oh, yeah.
Yeah.
I
That's
don't know
the
if it's
deal.
appropriate to waste this committee's time. I just thought since it was licensing, I would bring it up, because we were kind of shocked by it, to be honest
Yeah,
with you.
that's the new DOL initiative to try to ensure that everyone who's doing ERISA audits and employee benefit plan audits are properly licensed in the state in which they're operating.
You don't
Here in-
require
Operating
that.
in Kentucky. Okay?
But the parent company was in
And
Texas.
headquartered, I guess, would be the, we don't have any kind of requirements for that, do we? I mean, if
DOL has sent a list. In Tennessee, we're more concerned with making sure they have proper peer review done, and that is something the TSCPA is clearing for us right now.
let's say a firm goes into Georgia and does a pension audit for a company headquartered in Tennessee, they're not registered in Tennessee, they don't set foot in Tennessee, would we require the same thing?
No, we don't require that they be licensed in Tennessee.
That's my point. I mean, I think Texas is kind of out there on an island on this issue,
Could be,
is my perception.
yeah.
Do we want to require Texas firms that do?
If they drive through
No,
Tennessee.
no vengeance
Yeah,
there.
If
No,
they drive
if they
through
do
our-
any work on a company who has a parent company in Tennessee, like some of our healthcare companies, that we might send them a little letter, or
Only Texas.
only Texas is what I'm thinking.
Okay, Mr. Eldridge, before you adjourn, I have one more email that I'd like to read for you. This is a question from a licensee. Here's the situation. I am considering retirement, but would like to be able to continue with a limited amount of work in my specialty areas of business valuation and fraud investigation, as I am a CFE and a CVA. If in retired status, the NACVA no longer requires that I maintain my CPA license, but does limit the number of valuations I can perform. The ACFE does not require a CPA license at all. Question. If I terminate my CPA license completely and drop membership in the AICPA and TSCPA, is it legal for me to continue to perform business valuations and conduct fraud investigations under the standards of the NACVA and the ACFE?
Are you asking us?
I mean, so he's terminated his CPA license, right?
No, he hasn't yet. He's
22.
considering.
He's
But
considering.
isn't that I mean, in the question, didn't it say if he terminates his CPA license?
Yes, if he closes his license, can he do fraud investigations and business valuations using
There
the
are
CFE?
people out there who are not CPAs who do both of those things.
But if you have been a CPA, what is our stand?
He's no longer holding himself out as a CPA, so it seems to
So
me
it's as
this
if
board
you-
has no
Is it as-
interest in him.
Yeah.
Is that
What does,
true?
what is the CVA? What does that stand
CVA
for?
is Certified Valuation Analyst.
Analyst. So
CFE is Certified Fraud
fraud examiner. Yeah.
He could have gotten both of those credentials without being a CPA.
Well, there's people out there that have those credentials without
Not
CPAs.
CPAs. Yeah.
Wouldn't think it would be relative to us if he retires his
Except his
license.
license, yeah,
Doesn't matter.
I don't think. I mean,
He
it
couldn't
seems to
retire
me
his license, he'd have to close it.
But I think we need to be clear on that.
Yeah. Okay.
And I have a question, too.
Yes,
If we
ma'am.
have something that we want to be considered, and this came about because I was audited, and in the process, I was asking Karen some questions. We were debating, looking at the fact, I was actually looking at credit hours that you take at a university for CPE. And one of the things that came up was that we have no restrictions on whether the person continues to audit the same course over and over again. We have restrictions on whether you teach the course, which there seems to be strange there, because if you're teaching a course, particularly if there's a book change, that's almost like a completely new course in the amount of work you have to do. But you can audit the same course over and over again and get a huge amount of CPE. And I would just like to have that, and I will not, I would obviously be in a position where I could not participate in a vote on it, but I would like to have it on an agenda or somehow
We will put
discussed.
that on the agenda for the October meeting.
Great.
Mark, one quick question, and we'll adjourn. But back on the person that he wanted to close his license. What is the rule requiring that? If, let's say he closes his license, he continues to hold himself out to be a CFE and a CVA. In his marketing literature, can he mention he was a CPA, or what's the rule on that?
There's no clear and fast rule on that. That's where we're having a little bit of a struggle. It appears to me that he could say he was a CPA from 1978 to 2013, 2014. He could not say he was a CPA now. If he gave definitive dates of when he was a CPA, then I think that's valid advertising. Wouldn't you agree, Mr. Whitaker?
Yeah, I would say so. I mean, I think it's a distinction between, an actual recitation of circumstances from times gone by versus a current holding out today. And if he's not doing the holding out today with no license and simply stating, license as a CPA for these dates certain, then I think that's probably fine.
Anybody that loses their license for whatever reason, whether they voluntarily or involuntarily, they could still hold themselves out to be a CPA during some period of time?
It might be a little stickier question depending on the circumstances, and I wouldn't really want to opine on that without knowing the specifics, but, you know, just from a practical perspective, I'm not sure how much good that would do, because like, oh, well, you were a CPA up until this time, well, why are you not now? Well, my license was taken away. Oh,
I
okay.
surrendered my license.
If in fact you surrendered it, but that's kind of a cross the bridge when we come to it sort of thing, but I see your point.
Any other items?
Any other miscellaneous questions anybody wants to throw out?
We're adjourned.
Nice.
Can't use white, we don't have any beige yellow.
No.
Probably some somewhere.
Good. Do enough business with them.
I had a bad experience in law school. The firm I was clerking for, they gave me a beeper.
It's been in the fast lane, Bill.
Volume, and I'm sitting in the middle of my dang business associations course about 10:30. I mean, I'm like, there are dump trucks backing up that are quieter than this. And I'm freaking out, like it's a bug or an animal attacking me, and I couldn't get it to turn off. So finally, I just.
Are you getting a message?
Close me to death.
How far away could y'all be?
No, just to be at a right angle.
But I think it's good now.
I think they're right.
Your response is, I need to take this.
Like, do you need to?
How was your drive, Casey?
Good. Just a few sprinkles. Yeah, it was
Yes, I could.
We
actually
had a
okay.
heck of a storm come through Memphis yesterday. It rained.
We've been having storms about every day, it seems like, but just looked rainy all day, but never really. I mean, I hate to drive when it's just a mist
Oh,
and keeps
yeah.
it, but it was okay. No problem.
Do what?
Already signed.
Yes, exactly.
This flop is-
Stuff
envelope
else?
that you
Oh,
gave me.
really?
Yeah.
Oh, I thought that's fine.
Yeah, I can bring back to you.
Yeah, no,
I would have brought it today, but it's on my calendar for tomorrow. I don't remember anything
No.
if it doesn't pop up.
that's fine. Hey, all I wanted was the confirmation that I passed.
Get your audit done?
I got the audit.
Is that a calendar year audit? How do we do those? Are they calendar? You're doing yours for last year. Okay. Prior year. Where did Mark go? Ready, Mark?
Yes, sir.
Okay. I will call to meeting the executive commit, or call to order the executive committee meeting. First on the agenda is a request for licensee lists for inclusion in the 2014 practice analysis survey.
Yes. Have you all read this? Let's see licensing list inclusion request. This is coming from NASBA. The AICPA is doing a practice analysis in order to get a new exam launched in 2016, 2017, sometime along through in there. The practice analysis is designed to revamp the exam, if you will. They want to be sure they have information on the exam that is pertinent to CPAs entering the profession right now. So they're doing this practice analysis. They're asking us for permission to use our licensee list to poll some of those licensees to determine what they think the entering requirements are going to be. Now, they give you a list of how will the data be used, who's going to be sending out the survey, assurances that the list will not be used for any other purpose. They're going to be drawing these lists from the ALD feed, which is our entire licensee database. So they have the option there of sending it to anybody. One of you may receive a questionnaire regarding the AICPA practice analysis, but they're trying to get as much current information as they can.
Chris, are there any state rules that would prevent us from sharing licensee information with outside parties?
Know that I've been squarely presented with that question yet, or at least not in this context.
In effect, that's where we find ourselves, is sharing a list of licensee names or firm names. Is it just firm names?
I mean, I guess in theory, you would almost have to start from the perspective that.
They want a list of our firm permits that are issued, is the way I look at this. Is this?
Right, well, I mean, that's probably a public record.
That's what I'm wondering. Is it a public record, and what are do we even need to be voting on this?
Well, I mean, obviously, if the board has any input or something it wants to have on the record or for a meeting, that's fine, but I think where it may require a little more analysis, if the board's inclination were to somehow try to say no or limit it in specific ways or something like that, then a little more research might be required to see if partial redaction or withholding might be permissible in certain circumstances or not so much. I don't think the Open Records Act probably requires that you send out all these folks like home phone numbers and email addresses, but especially for firms, you know, their office locations and things like that, stuff that the board regulates would seem to be fair game for disclosure, especially for something like a professional survey for an organization that's recognized by name in the rules on multiple occasions. You know, I think you'd have to start from the presumption that it's probably a valid request and go from there, depending on what, if anything, the board wanted to try to do to limit it, and depending on the reason, and then kind of take it from there.
Have any comments?
Yeah, I read this, and I guess my reaction, I think we should do it.
Yeah.
Provided we're not violating any kind of privacy restrictions. If you're saying they're actually just wanting to use our information in the national licensing database, Mark?
Yes, they're going to pull it from the ALD since we are on the ALD, so it's all public record anyway.
So that's all open to anybody
Yes, I
already.
just wasn't going to sign this without the board's
Yeah.
approval.
Oh, I got you. And I definitely don't want to make it any more difficult than it has to be. I'm more concerned
I
with
think we ought
violating
to,
policy
yeah.
or procedure
Yeah.
more than anything.
I think we should do it. I mean,
Okay. Do you want to look into that anymore, Chris, and just make sure we cross our Ts and dot our Is, or does you think it even matters? Or at least review the list before it goes out?
I don't know that reviewing the list would do any good, but I just may take a quick scan through on like the Federal Privacy Act or something just to make double sure, but
I just want to make sure we're not held responsible for something later that we shouldn't have done.
sure. But I'll take a quick look at that, and if I find something that makes me think that, well, really shouldn't do this at all, then I can let Mark know and we'll go from there. But if not, and the board's inclination is to go forward with this, then, you know, we'll just do it.
Okay. Thank you. Next, we have the financial information.
What you've got in front of you, the operating results through May of 2014. We haven't gotten the numbers yet for June. Those are always a little bit late because that's when they try to assess all of the year-end costbacks. We're taking a good guess at year-end costbacks at this point. There's really nothing out of line here that I can see. We're projecting a net revenue to reserves of about $33,000. It's a little bit more than the $10,000 that our budget projected, but we did not get our fees lowered for 2013. They'll be the $110 fee will be in effect for 2014, and the budget that we passed had the $110 in effect for 2013.
First column is identified as fiscal year 2014. You really mean that to be 13, don't you?
Oh, I mean that 14, Bill.
Fiscal.
That is through the end of May, is it not, Mark?
Yes.
That column, it would help if it said fiscal year
Year-to-date.
2014 actual May 31.
Okay, it's duplicated there. Okay.
Yeah.
Yes.
Helpful to have some explanation as to the variances.
Put that in there just for you, Mr. Blofus. I did want to point out that on the state professional services, our rent did decrease significantly. We had been paying $54, $57 a month. That's what we had budgeted, and they reduced it to $29.08 per month. But they also reduced our square footage significantly. So. We're going to be coming out ahead. That's the main thing.
Upgrade that we heard about at the last meeting or at a recent meeting is going to be
Correct. That will be coming out of the reserve fund. And our cost was about $70,000. That's what we sent to F&A as part of our budget.
Any other questions? Okay. With that, we'll move into the travel report.
You should have reports for Don, Ray, and I for fourth quarter 2014 on our travel. You'll notice mine was a little bit more extensive than usual due to the requirements of the NASBA chairmanship that I'm performing right now. I did go to San Juan. I attended both the NASBA Eastern Regional and the Western Regional. I did a couple of presentations.
Mark, again, this information is through June 30 rather than May 31, right?
Yes, this information is through June 30. Yes.
So this is it for the fiscal reporting year
This will wind it up. Yes,
Yeah.
Casey. My term ends, I have to go to the board meeting October 30th and 31st, and the national meeting is November 2nd through 5th, and that's when my term ends. So I just have a couple more months. John and Ray both did a couple of presentations. Most of their travel is going to be concerning investigations.
Any other questions for Mark? Okay. Mark, do you want to go over this discussion for a peer review transparency?
Yes, sir. Let's introduce peer review transparency. I think it's going to be a topic over the next couple of years. I think that it's something that we need to take a look at. If you have your rule books, or Karen, did you load the rules on here?
No, I don't believe they're on here this time. I'm sorry.
Anyway, basically, in Tennessee, the peer reviews are completely confidential. No one has access to them except the TSCPA. With firm mobility becoming an issue nationwide, one of the roadblocks to firm mobility is the fact that other states can't depend on us to look at our peer reviews to see who's doing what kind of work. I think that we're going to have to examine peer review transparency and decide whether or not we want to overcome that particular stumbling block. I'm going to the TSCPA Board of Directors meeting in August, and I think I'm going to raise this issue with them to see where the TSCPA stands on it, because clearly it's nothing that we want to do without the TSCPA support. But I think that it's time that we start discussing it so that we can decide whether or not we wish to pursue it hot and heavy.
What percent of other states have similar rules to ours, or are we in the minority, or are we in the majority?
We're in the minority. I think there are 4 states that have confidentiality laws similar to ours. We are a very small minority. Ohio, is it Ohio, Missouri, and I want to say Indiana, but don't hold me to that, Casey. I can look that up if I need to, but I think those are the 3 other states that have.
Brad, do you have any commentary you'd like to share on this issue?
Nothing strongly. Mandated peer review for licensure firms. We implement.
Don't have any commentary?
No, I think it's time to discuss it. I mean, particularly when you talk about firm mobility, and if this isn't,
Okay. What's your intent? Do you want to discuss this at the board meeting tomorrow, or?
Yes, I would like to discuss it at the board meeting tomorrow. I'd like to
Okay.
get a feel for the full board to see.
What
kind of
direction we
support-
want to go in?
Yes, what
Okay.
direction we want to go.
Well, we'll just bring this up as a topic at tomorrow's meeting. Okay.
We're subject, if a firm is subject to PCOB oversight, that is,
According to our laws and rules, we're not supposed to look at those either, Bill.
because they're subject, because we aren't looking at public companies.
PCLB is doing those reviews, correct? So no, the TSCPA is not doing them, but
PCOB results are not confidential.
correct.
Okay. Any additional topics that need to be discussed? Okay. Just for a note for tomorrow, I've got a plane flight out of Memphis at 7 tomorrow night. So I've got to leave here by 1 tomorrow, and I know we've got some formal hearings potentially tomorrow. Do we know what's going on there?
There were originally 3 formal hearings on the docket for tomorrow. One of the respondents retained counsel, so we're going to be doing an agreed order of continuance to October. And I'm hopeful, if not optimistic, because you never know with these things, but hopefully we can settle that one, and then we don't have to try it. But the other 2 will be going forward as scheduled, and, it'll be up to the administrative law judge to decide whether our efforts at service were sufficient to allow us to proceed, or whether we need to do stuff and come back.
Okay. I only bring that up because, Casey, you may have to step in for me if that drags for any extended period of time.
plane going, I might.
I'm going to Colorado.
Casey, you'll be fine as long as he's here long enough to handle all the formal hearings. That's the
Well,
hard part.
my other point would be that maybe, we've got everything on the agenda at 9 a.m., is that correct?
Yes.
And so in theory, any of the board business that needs to be conducted, I know we got the law judge, we need to be mindful of their time, but maybe some of this administrative stuff we could try to knock out if, in fact, I mean, I don't know how y'all feel about that. We need to do election, and we need to do several things, and maybe we could knock out a few of those things first. But I'll be at y'all's mercy for that, but just a little notification there. All right, with that, I think we're adjourned.
Yes, sir. Thank you. You want to go turn this off?
Well, everything's on the agenda. We have some board business from 8:30 to 9, correct?
A little bit.
But then everything else, I think, on the agenda, we just have a 9 o'clock time for the sunshine stuff, so.
Wife is, they've been into it big time with her. Her family's got a big farm. Radio, and she just went to get the hard copy?
Get a hard copy for Mr.
Okay.
Bluffus.
Okay. On, are we on? Yes, sir. Okay. This is called to order the meeting of the Probable Cause Committee. At this point, we have a quorum, it appears. Mr. Mills, would you like to give your report first, sir?
Yes, sir, I'll be glad to.
Mr. Chairman, it's on your little thing. I just can't find who named it.
Right above travel.
These
S.
things are alphabetized. I'm amazed. Yes, sir. If you look at your status of open complaints, you'll see we're continuing to make progress as we were directed to by Mr. Alexander, I think, several years ago. We're down to 38 cases right now as of today's date. And as you can see, we're probably going to hear between 14 and 15 tomorrow, counting the formal hearings. So we're in good shape. We're going to try to find some more. And if you'll notice, we've still got 10 in the open status. I think some of those will be going to legal if they haven't already. So we're trying to keep the fresh blood flowing. That's about it in a nutshell. If you'll look at the third page, though, you'll see this beautiful, beautiful color chart.
That you wish you could take credit for.
That I wish I could take credit for, but I have to tell Ms. Condon did that for me and came up with it, and she knows how CPAs love charts. So I encouraged her to put it in there.
She's coming back to take her bows now.
Good. As she deserves.
Very nice chart. Commend you on your good work and keeping up with trying to stay on top of the cases so they don't become stale. There any discussion or questions for Mr. Mills? Hearing none, we'll approve it, and thank you, Mr. Mills. Is there anything that you all would like to bring up to us that we can do to help? I know Mark, and I would commend you, Mark, on your presentation at the Tennessee Society of CPAs Convention in Kingsport last month. Particularly your comment about that, remember, members, you are our ears and our eyes. If you see something that doesn't look right, let us know. And if we can maybe do a piece with Brad, something like that to remind people. I think, there's nothing wrong with saying, hey, I got a question about this. You're not necessarily filing a formal complaint. You're saying, look at it. Is there anything there?
Right. And we do need members and the licensees to be sure that they report anything they think is suspicious to us.
And even bankers would be a wonderful source if they would take the time. I know we've had some results in the past from bankers, but just letting them know that it's out there. Mr. Whitaker.
Thank you, Mr. Chairman. Your iPads before you have a draft legal report with 10 items on it. This is up from the number that was originally submitted on the draft. We were able to get some additional investigation reports completed in the last few days. So in the interest of, as Bill's termed it, keeping fresh blood in the pipeline flowing, went ahead and added those prior to today's committee meetings. As I mentioned, there are 10 items, and of these, there are just a couple to look at specifically and keep these things in mind as you're reading them. On item number 1, the recommendation is for a $2,000 civil penalty. That would be based on the failure to exercise due professional care, and then that'd be $1,000 for that, and then $1,000 for failure to timely respond to the complaint. And it's kind of my opinion that the only way committee or the full board could go higher than $2,000 is if it was deemed that the failure to exercise due professional care was an ongoing course of conduct with one or more specific definable actions that for which multiple violations under that same umbrella could be assessed. And if the committee or the board were inclined to consider some sort of probation in addition to the civil penalty on item number 1, I would not be adverse to that. And then item number 10, unlike the majority of the complaints, this one is being recommended to be referred directly to litigation for a formal hearing with no settlement offer at this time. There are a couple reasons for that, chief among them being the unlikelihood of settlement at this early juncture. It's a very in-depth and complex case for which expert witness testimony may be required at some point, be it during the investigation and or at a formal hearing if it's not settled. And then also by doing it this way will give Mr. Mills and, whoever else needs to work on this and take a little additional time to really firm up and nail down the facts as we can determine them prior to sort of giving a preview of coming attractions and putting anything like the allegations that we might expect to prove at a formal into a consent order, but also allow us to continue to comply with the performance measure, the 180-day performance measure set for us by the department and the division. And so that's the reason for that recommendation at this time. And once the committee members have had an opportunity to read the report, I'm happy to entertain any questions about either of the two items I've just referenced or anything else that there are questions about. So with that, I'll turn it back over to you, Mr. Chairman.
Okay, thank you. If you all would take a moment to read the rest of the report, since we didn't have, but there were maybe 4 that we mailed. But there were 4 on the original one. And we've got, if you read the other 6, are the original 4 the first 4 in this report?
Yes, sir. Those,
Okay.
the first 4 are identical, so if you've reviewed those already, nothing has changed since you looked at it.
All right, on the first case,
Excuse me, before we leave number 10, the complaint, was it filed by the client?
The complainant in this matter is actually a now former employee of the respondent firm, and as best I can determine it right now, and Mr. Mills can speak to this, but there has been a resolution as between the parties of the employment piece of this matter. So it's not like the one that we had looked at earlier in the year where there was some question about, is this employment related? Is it really not? In this case, since the respondent and the complainant were able to work out an agreement as to their professional divorce, as it were, and do that without litigation, and so that both parties could at least part company in that regard, while not thrilled, at least not in court. That's not a consideration in the write-up or summary or the facts as presented. So what you have before you is strictly, a factual summary as best we know it right now.
and all we're doing is actually forwarding it to legal so that it's, or to the litigation, so that it is for a formal hearing.
But it's not, there's no settlement recommendation at this time, and there frankly is there's no way this case could remotely possibly be tried in October, and probably not even in January. I mean, it's going to be a little while. And, you know, what we didn't want to happen is to leave it in such a posture where it starts to adversely affect the board's performance measure from a division perspective, but also to be fair to not only the complainant and the respondent, but also just the complaint process generally, to give it time to breathe and to work and to do what needs to be done. And by putting it in this posture, but without, you know, the board potentially opining via a settlement offer on which all of the salient facts might not be known today, it'll still allow the process time to work and allow the board to do what it needs to do to maintain its performance levels.
Has our internal investigation been done that we can do, short of, you know?
I would say that a substantial majority of it has been, and again, that'd be more of a Mr. Mills question, but I would say that if it came to a point where we were prepared to recommend a settlement offer and or proceed to a formal hearing, that's more likely than not when we would have to determine, A, if an expert witness is required, and B, if so, what kind of expert and what do we need from them. And we're just not quite there yet. And the contracting process takes a little time as well. So and again, Don can speak to this, but there may be some more things that he's wanting to dig into on one or two of the pieces of this complaint, because there are like 3 or 4 potential issues here. And I'd say, based on our discussions, we're probably pretty comfortable with 2 of the 4 and what we think, but the other 2 may still need a little further consideration.
Mr. Mills, my question, I guess, is where I'm having to head with this. I keep hearing, let's push it and get on our performance measures. And I understand we need to stay there, but I don't want to shortcut something just to get it, to get the check mark over here and or a little gold star that, I commend you all for trying to stay on track, and we don't want to drag it down, but I don't want to let that overshadow complete investigations before we just say, let's move it on either. And I guess, are you comfortable with this as the investigator?
I am to the point where I feel very strongly that we may have a problem. I've been assured that I can continue with my investigation. I think that the allegations are so serious that they've got to really be looked at, because
Okay.
we
Very
want to
good.
make sure the T's are crossed, the I's are dotted. So yes, I plan on continuing my
I
investigation.
just want to be sure that that's where we're headed with it. Okay, thank you very much.
And also, Mr. Chairman, if it were a situation where, for example, we were confident of at least a preponderance of evidence potential finding on 0 of the 4, or, maybe just 1 and it's questionable, we probably wouldn't move it in that direction going forward. At this point, we might just say, hey, look, the performance measure is 75%, and, we're several percentage points above that and have been for a while. And, maybe we just make that one of the 25% or so that doesn't make the 180. But given where we are and what Mr. Mills has uncovered so far and continues to investigate, I think it's an appropriate step forward for this case, and we did consider all potential options of what to do with it right now, notwithstanding the 180 days, and if so, what's the right thing, not just the fast thing. And I think that's kind of what you were speaking to.
Where I was headed, thank you. Okay, each of you, I assume, has had a chance to read over all of them. We have several penalties on 1, 2, let's see. First, well, there's only 10. Let's just take them as we go through them. On what we want to have a motion for is a recommendation to the full board to accept the recommendation of our staff attorney for sanction on these, or disposition of these cases. On 1, you've had a chance to read it. It's recommending a formal hearing for the revocation with authority to settle via consent order upon the respondent's payment of civil penalty in the amount of $2,000. Now, is that, if he's what he would say, or what we're saying here is that if he will pay the $2,000 and hand over his license, then we don't have to have the formal hearings, what you're asking for. Is that correct?
No, actually, it's not
Or
fully.
is that in the?
No, the language that says formal hearing for revocation of the respondent's CPA license, that first part is kind of stock boilerplate language, because that is included and phrased that way so that the board retains jurisdiction to impose discipline all the way up to the maximum available possibility in the event of a formal hearing. So that first piece is kind of like a contingent part, and then you finish it out with authority to settle by consent order. So what the board is saying is, we are going to offer you the opportunity to settle by consent order for this $2,000 civil penalty, but if you don't, then the next step is a formal hearing up to and including the revocation of the license, but it could be less than that, and often typically is. But that is simply language that, in my mind, is that I've been inserting pretty much since I've been doing this for clarity purposes, and to ensure that the board is not somehow limited at a future formal hearing by an attorney's argument, oh, well, you didn't say that you could do this all the way up to the max, so my argument's going to be, as respondent's counsel, that you've already said what the cap is, and we're just talking about something up to that range and nothing else.
Anybody, any of the committee members have any problem with no sanction other than the penalty if we settle?
I mean,
Okay.
Entertain a motion then to approve number one.
So moved.
Have a motion and a second. All in favor say aye.
Aye.
Opposed, like sign. Motion carries. This is the CPE case. Actually, the next two are, both of them with penalties, one of $1,000 and one at $500. Accept a motion to approve the recommendation.
Mr. Chairman, can I ask a quick question?
Sure.
What was the difference between the $500 and $1,000?
About $500.
I appreciate that. As the lawyer,
It appears to be failure
It
it appears to be failure to respond timely.
Okay.
Based on what I read, is that correct?
So-
Mr. Crocker asked me the same question when I presented this draft to him originally, and as between these two respondents, the respondent in item number 2 essentially had to be dragged kicking and screaming to compliance, whereas the other person did not. Respondent number 3 responded to the complaint in a timely manner, kept board staff and investigators apprised of his ongoing efforts to remedy the situation, and eventually did remedy the situation. Just took a little time in getting the CPE, but because failure to timely respond to a board complaint is a separate disciplinary ground, apart from any whatever underlying violation led to the complaint, it's it just didn't seem like the cases were exactly the same, and that these two respondents should be treated the same when one, yes, admittedly had the violation, but from there through the complaint process was kind of responsible on top of their game, and the other person was substantially less so.
Thank you.
Both of them, there's a reference to revoking the license. Is the explanation on this the same as the one that that's just that in an extreme case, the license could be revoked?
That's correct, Mr. Bluffus. And if you went back and looked historically at legal reports over time, for pretty much any complaint where a consent order was authorized, you would see that same stock language. And, that's everything from, a $250 civil penalty and nothing else to revocation and a 5-figure civil penalty. Just trying to give the board the maximum flexibility and leeway and make sure that it can do what it needs to do in the event of a formal hearing.
Recommendation or motion to approve 2 and 3 to the full board.
So move.
Second.
I have a second. All in favor say aye.
Aye.
Opposed, like sign. Ayes have it. Except I think that was 2 and 3 instead of 3 and 4. Okay. Looking at 4, 5. 4 and 5 are dismissed the case because investigators have found that there was nothing to have the case open for. They had complied. Numbers 6 has closed with cease and desist letter. Number 7 is with a letter of warning. It's one of the Texas cases that we seem to have. Number 8 is a cease and desist. Let's stop there with number 8. Does anybody have any problems with any of those particular ones or questions? Entertain a motion for approval.
So move.
Have a motion
Second.
and a second. All in favor say aye.
Aye.
Opposed, like sign. 9 is a little bit different. We want to put it in litigation monitoring status.
That's correct, Mr. Royston. This respondent is from Mr. Mills' neck of the woods, so he's the investigator for this matter. looks like this particular respondent has gotten himself into some fairly serious problems. There are civil lawsuits pending against this respondent for various financial misdeeds, and then there are also, I believe, felony criminal charges pending as well, arising from that same conduct. And since it's related to the substance of the board complaint, this respondent did wisely, in my opinion, because he's going to need it, retain counsel, and that attorney spoke with Mr. Mills and like, hey, what can we do here to make sure my guy doesn't have to incriminate himself in criminal court and potentially put himself in jail responding to a civil board complaint. So in those kind of scenarios, that's typically what we do. I'll draft a consent order. They'll review it. If there's any language tweaks needed, we'll do that, and then the respondent and their attorney will sign it. And then I try to include language to make it where either the civil and criminal suits are completely disposed of and we know what's happened, or if there's sufficient independent evidence that is kind of like ironclad and we can just go forward and we don't need the respondent's cooperation or participation, and or if it's sort of an emergency public health, safety, and welfare consideration, then the board will have unilateral authority to pull it out of lit monitoring in those circumstances. But short of that, then it'll stay there until the judicial process has run its course.
You just had the key answer right there I was looking at, is that protecting the public, there's enough stir already about this one that the public's pretty well informed, I would assume.
Yes, I would say so. It is a matter of some publicity in that area, and I have a hard time believing that anyone who has access to an internet connection or basic cable probably doesn't know about this.
Thank you. We'll put that one in with number 10. I think we've discussed number 10 already. Do I have a motion to approve numbers 9 and 10 as presented?
So moved.
Have a motion and a second. All in favor say aye.
Aye.
Opposed, like sign. Motion carries. Is there any further business to come before the probable cause committee today?
Sir.
We are adjourned.
Thank you.
With position.